Hello, I'm Bernard Nomberg with the Nomberg Law Firm in Birmingham, Alabama. And we're doing a series of videos here that discuss about how the impact of the pandemic is dealing with the laws and rules and regulations for the people of Alabama and other states. But more specifically, we really focus on Alabama since we practice here. But one piece of news that has come out this week is that OSHA, the Occupational Safety and Health Administration, has changed a long-standing position about dealing with certain types of conditions in the workplace, specifically dealing with the pandemic. And now they are requiring employers to determine if COVID-19 is work-related. And I'm going to go over just some of the highlights. I'll put a link to this video so you can read further, but this is a real shift in past policy that may be helpful for workers who may think that they have contracted the condition based on work environment, work conditions. And if you're an employer, you particularly want to pay attention to this. And if you have employees, or if you're an employee who contracted COVID-19 and you suspect that it came from a workplace exposure, that's what this is dealing with. If you're the employer, you're required by OSHA to determine if COVID-19 is work-related. You have to be proactive, and that's the new rule. And here is some of the key information about that. Under the Occupational Safety and Health Act, employers are now required to record and maintain records of occupational injuries and occupational illnesses. And by definition, occupational illness is one that is work-related. Earlier in the pandemic, many employers were concerned that they might be required to record the existence of all COVID-19 cases in the workforce. Well, OSHA has calmed a lot of those fears down and put in guidance that it issued in mid-April. And I'll put a link to that as well. The guidance from mid-April basically adopted a common sense position that employers aren't epidemiologists. They shouldn't be required to determine if it is work-related. And it said that they couldn't enforce recording of all of these in the workplace unless, and this is the key, there was objective evidence that COVID-19 exposure case was work-related. And this would include a number of cases where people work very closely together without any alternative explanation as to why the condition existed, and there was evidence that was reasonably available to the employer. And that type of evidence would be just being directly informed by the employees, as well as information where the employer regarding the employee's health and safety in the ordinary course of managing its business, they learned of these things. However, effective May 26th, this upcoming week, this is being recorded the week before, employers now will be required to act as amateur epidemiologists, basically, and do proactive work. They're required to record a COVID-19 case as an occupational illness if the case is confirmed, it is a confirmed case of COVID-19 by the definition of the Centers of Disease Control and Prevention, the CDC. The case is work-related as defined by, there's a code of federal regulations that I won't get too deep into the woods on that. And the case involves one or more general recording criteria also under that same provision, meaning if an employee misses days of work or receives medical care beyond first aid, that could trigger that requirement. In determining whether a COVID-19 case is work-related, an employer is required to consider all reasonably available evidence. And while admitting that this determination can't be reduced to a specific formula, there's some guidelines by OSHA that is as follows, and there's a few bullet points here. COVID-19 illnesses are likely work-related when several cases develop among workers who work closely together and there's no alternative explanation. An employee's COVID-19 illness is likely work-related if it is contracted shortly after lengthy, close exposure to a particular customer or coworker who has a confirmed case of COVID-19 and there's no alternative explanation. An employee's COVID-19 illness is likely work-related if his job duties, including having frequent, close, exposure to the general public in a locality with ongoing community transmission, again, and there's no other alternative. An employee's COVID-19 illness is likely not work-related if she or he is the only worker to contract COVID-19 in her or his vicinity, and job duties do not include having frequent contact with the general public regardless of the rate of community spread. An employee's COVID-19 illness is likely not work-related if he, outside the workplace, closely and frequently associates with someone like a family member, significant other, or a close friend who has COVID-19, is not a coworker, and exposes the employee during the period in which the individual is likely infectious. Certified safety and health officers should give due weight to any evidence of caution pertaining to the employee illness at issue that is at issue provided by medical providers, public health authorities, or employee herself or himself. I know that's a mouthful, and there's a lot here, and I'll put it attached to this. There is some help, though, here for employers to pay attention to. OSHA gave a favorable burden of proof for making the work-related determination and recording requirements. If, after the reasonable and good faith inquiry, the employer cannot determine whether it's more likely than not the exposure in the workplace played a causal role with respect to the particular case of COVID-19, the employer does not need to record COVID-19 illness. Also, employers with 10 or fewer employees, and certain employers in low-hazard industries have no recording obligations. And those are some key facts for employers. There's a mouthful here. I know it's a lot of information to unpack. If you have questions or concerns about this, there'll be links that you can read further, or you can always give us a call at the Nomberg Law Firm.